how come some of the big marketplaces get away with like rampant trademark infringement? For example, Etsy.
They are permitting the owner to hit go on 1,000 takedown notices at once. The overall takeaway is that you're going to have risk.
In today's episode of Print-on-Demand Wisdom, I spoke to Eric, who is a lawyer that specializes in trademark and copyright law. This is an area of print-on-demand that is often overlooked, but it is super important. And our conversation has a lot of insightful information, including how to deal with single-word trademarks, whether all of the song lyrics out there and movie quotes are copyrighted, is it okay to sell designs related to Donald Trump or Kamala Harris, and important things to consider if you're selling AI art. And for anyone who wants to register a trademark or needs help with a specific trademark case, I will leave a link to Eric's contact details and his law firm's website in the description down below. Hello, Eric. How are you doing? Thanks a lot for coming on the show.
Thanks, Philip. Great to be here.
Yeah, I'm really excited today to talk about trademarks, which I think is one of those topics that confuses a lot of people in the print-on-demand space, especially beginners. So I'm happy to talk to you today because this is literally your job. Why don't we start with kind of your story, what you do, and then we'll get into some more specific questions about trademark, copyright, etc.
Sure. So I'm Eric Perrott. I am a partner with Gerben Perrott in Washington, D.C. We are a firm that only does trademark and copyright law. And it's what I've been doing as my entire legal career for the past 15 years has only been trademarks and copyrights. And so I've kind of worked with a wide variety of clients, a lot in the print-on-demand industry, but also a lot outside of it. I work with very large companies, but I also like to work with entrepreneurs, with mom and pop stores, people just with ideas they're trying to build. And I do my very small part to help them be successful, but it's always been very great to work with pretty much anyone who's got a brand, who's got ideas, and they're trying to build that. That is definitely the kind of work that I like to do.
That's nice. And I actually found you through Jay from Jay's Way Works, who's also a print-on-demand seller. So yeah, how's that been working with Jay? Because he does mainly POD.
Yeah, it's been great. So Jay, we've worked with for a long time, and we've worked with him on his brands and help him kind of solidify that he is has his different brands and he's known by them. And if someone else tries to use similar names, we make sure to kind of let them very nicely know that that name's already taken and to choose a different one. And so, it's been a lot of different things over the years, but it's always good. I think that hopefully I'm not speaking for Jay, but it's always good to have someone with a very narrow knowledge of the law. And I know a lot about a very small part of the law, which is trademarks and copyrights. And so I'm always happy to share that.
Oh, that's amazing. So you're like hyper specialized on the most important aspect for us.
Yeah. It is great because family events, it's like, well, I've got this legal issue. I'm like, not that kind of lawyer. It's so don't call me if you've got a DUI or if you are in jail, but definitely call me if you've got a trademark infringement or takedown notice. That's my sweet spot.
Just like Saul Goodman, who's like the expert for drug cases. Yeah, the expert for trademarks. Why don't we start off with your presentation then, which we'll also make available for download for free. That'll kind of give like an overview of trademarks and what you do. And just to let people know as well, I will leave a link to Eric's law firm in the description as well for anyone who does need help with trademark registration or protection.
Yeah, thanks. Trademark and copyright law and IP in general is a very has a lot of different elements to it. And I think people generally will use the word IP, but they'll also kind of change around the words. They'll say, I want to copyright that, but they mean trademark. They'll say trademark when they mean copyright. And so there's a lot of different vocabulary flying around. So I feel like it's good just to at least have a baseline of what we're going to talk about today. And the first thing, though, is what I'm talking about today, what we're talking about is not legal advice. I am a lawyer. I am not your lawyer or anyone listening's lawyer. And I don't just say that as kind of a cheeky thing that lawyers say. The reason why we say that is because small changes in your fact pattern and whatever issue you're dealing with and who you're dealing with it with can make a huge difference in the advice that I would give. And so anything we talk about today is going to be very general. And if you have specific questions, Philip, you'll put my contact information. I'm always happy to at least point you in the right direction. But yeah, anything we talk about, just take that with a grain of salt, that there are so many things that could be different about your situation that would make this not applicable and not something you would take verbatim. The other part to that is the word that we can have, like, I wish I had like on the background, like I
Big
think I can
poster.
light up every time I say it. It depends. This is my favorite phrase. It is the lawyer's best friend because for the same reason I said before about why it's not legal advice, there's so many situations that are so fact specific, especially in trademark and copyright law, that there's going to be a lot of things that you're going to ask me a question. I'm just going to say, the blinking light in the background, it depends, because that's just going to be the reality sometimes. So please give me some grace and forgiveness if I overuse this phrase, but I will try my best to actually not be slippery. I will try to give answers when I can, but sometimes the answer might be it depends, just because of how nuanced some of these arguments can be, and how kind of, and especially in copyright law, some stuff I just roll my eyes about because I'm like, how did we get here? And so even I, as a lawyer, feel that way sometimes. So just to let everyone know, that's going to be my phrase you'll see a lot.
You need to get a neon sign for sure.
And now I'm thinking about it. Yeah, I was jokingly said I was going to get a registered trademark symbol in the background that I'd light up every once in a while. But now I think it depends, and like a neon sign would be nice. And so there's three main types of IP law. We're going to talk about two of them primarily today. Trademarks, copyrights, patents. Patents are going to be the one we don't talk about as much, but they are the most powerful form of IP when it comes to how restrictive they are. But they also just tend to only apply to situations that are not as common in the print on demand industry. So, but if people have questions about patents, we can talk about it. But the main two are trademarks and copyrights. And trademarks are protecting brand names. They're things that identify a source of goods and services. So when you put a phrase on the front of a t-shirt, if a person is buying that because they like the phrase on the front of the t-shirt, then that is typically not a brand. That is something that they are buying because they like what's the design, the copyright, or in some cases, if it's copyright, they like the design, that's why they picked it. But they would go with your name because they recognize the quality of it. So if they see the Gerben Perrott website, then they're going to associate that with the quality of work that we do. And that's where company names come in handy. Logos, designs that represent the business. That's what makes a really good trademark, is something that stands in for all the good things and all the bad things. And that's one of the reasons why we have to protect trademarks, is that it is this shorthand for, I know I'm going to get a quality shirt. I know I'm going to get a quality print. I know that the design ethos, I like the person who makes it. All these kind of decisions that go into that are all represented by a brand. And that's a little romantic, but that's the way I like to think of it, is it is just this shorthand for everything good and bad and quality about your business. That's a trademark. A copyright, on the other hand, is a creative work. So a design, something you wrote, something you drew, something you took a picture of. There is a limit. It has to rise to the level of creativity, which is a very vague and gray area. So a single word is not subject to copyright law ever. A short phrase, the guidance is that is also not subject to copyright law. But there is at least a point in which you can start to get into designs and things like that that do end up getting protected from exact copying or very, very similar copying. Trademarks protect against confusing similarity. So would consumers think that you were related to this other brand or endorsed by or associated with? Copyrights protect exact copies and very close copies. And they work together, and people conflate them, and they are often used in ways they shouldn't be used. And we'll talk about that later. But those are kind of the main tenets of the two, one being brands, the other being designs for trademarks and copyrights. And that's where most of our conversations start. There's a lot of gray in that, but that's kind of how we usually split up the two when we're talking about that. Really, almost anything can be a trademark, but a symbol, a set of colors can sometimes be a trademark, because you can think of different brands that you would see the Tiffany blue on a box, and people would get very excited because it's a very expensive jewelry that is known for that kind of powder blue. There's a lot of things like that. There's also things that are not trademarks. And when something is so commonly used that consumers would never think one person owned it, then that stops being a trademark. It's called failure to function, and we'll get into that as a
Yeah, sure.
common issue in the print on demand, because a lot of folks are trying to monopolize phrases that I don't think they should be. But then there's also some that might look like that's what's happening, but it could be actually establishing a brand. And so that's generally with trademarks. Yeah, this is on for anyone listening on the screen is Under Armour's website, just to kind of do some trademark spotting. The Under Armour logo, this is the two U's interconnecting, is up in the upper left-hand corner. The word Under Armour is in the footer. There's a bunch of kind of different designs that are incorporated into the website. All of these are protected trademarks for the Under Armour company. Adidas is very, very aggressive about their protection of three stripes when in connection with clothing and t-shirts. And so if you apply for something that has three stripes in it, expect to get a notification from Adidas that they don't want you to do that. There's also kind of the different stylizations that Adidas has on their boxes, and all of those could potentially be trademarks.
Hmm. For the people listening on Spotify, we were just looking at a box there of Adidas shoes and had the
Yeah,
stripes across as well. So I'm guessing they would even go against stuff like that if someone tried to sell
right.
their shoes in a box with stripes on it.
Yep, absolutely. That would be something you would expect to get a letter from Adidas, from my experience. Finally, then on the screen now is a Maker's Mark whiskey bottle and a set of AirPods from Apple. Those are indicative of something called trade dress. I think in print on demand, we don't run into these issues as often, but I know that a lot of you will also have different types of businesses about, on Amazon and things like that. So I think it's important to note that even the shape of a product could be a brand that identifies a company. So when you see a set of Apple, I've got some right here, you look at these and you think, oh, I know who makes those. And if they're a knockoff or if they're a look-alike, then you might, or another consumer might think that that's what they are just by looking at them. Like, oh, those are an Apple product. And the same thing with Maker's Mark, this dripping wax on the top. They have a registered trademark in that, and it's called trade dress, which is an unusual term, but anything that's the look and feel of a product could also be a trademark.
Interesting.
And I think that this is important to print on demand folks, is that trademark, something, not all words are trademarks, but then not all trademarks are given the same level of protection. That we have it called a spectrum of distinctiveness, which is also one of those words that I love from trademarks, that we have like a good marketing for trademarks of spectrum of distinctiveness as a word. But it basically means that on one end of the spectrum are descriptive words and phrases, and those are things that directly describe some part of what you're providing. A blue t-shirts. I mean, that is so generic, no one would ever be able to protect it. But then you get into words like, cold and creamy for ice cream, quick fix for repair services, things like that, that say exactly what it does, and it makes it very quick and easy for consumers to know exactly what the product is. It makes for a terrible trademark because you don't have anything that connects it back to your business. It tells you this is what the business does. On the other end of the spectrum are completely made up words, or words that have no connection with the products or services that they're selling. These are the most powerful trademarks because they have no connection with the underlying goods and services, and therefore very difficult to market, because any recognition that you get in that name goes to the uh, goes to you, as opposed to kind of it being something that describes what the product is. And so those are harder to market, but those are the most strong, most powerful trademarks. Apple for computers, Kodak. I mean, Kodak's a little bit of an old brand now, but very distinctive. No reason for anyone to use that phrase. And then somewhere in the middle is where most trademarks live. They say something about the product, but they are not arbitrary. I'm thinking of like Blue Apron was this meal prep that it says something about kitchen. It's an apron is something that's used in the kitchen.
Mhm.
Okay, I know that I might put on my apron to use this, but it doesn't directly describe what they do. And so those are called suggestive trademarks, and those fit somewhere in the middle. And that's important because figuring out exactly where these phrases fit help you know where to invest your time, because you are going to, if you have a descriptive trademark like soft t-shirts, then you're not going to want to spend a ton of time trying to become the exclusive owner of soft t-shirts. It's going to take, if you're able to do it at all, I don't think you will, but you'll spend way too much time and money promoting a descriptive phrase, and then everyone gets the benefit because no one understands that it's connected to you. So there is a important, and what I want to emphasize here is that anytime a lot of print on demand will end up using or at least referencing IP that belongs to other people. The best way to avoid confusion is to have your personal brand be strong, be so strong that consumers are buying from you personally. And then anything you make, they would not be confused into thinking that you were Apple, that you were, or not, that's not a good example, but that you were, Warner Brothers or any of these other kind of IP owners that might be coming out and saying, well, you're referencing my IP. If your personal brand is strong enough that people recognize you as the provider of that it's much less likely they'll be confused into thinking you're someone else. And so I think that's why it's important to note that regardless of how you're using others' IP, you should always be building your own brand and your company and your general, you should have your own trademark that really does shine through whenever you're working with things.
Just for clarification there, I'm guessing this applies to people who have their own store, their own brand in a sense, compared to, I think a lot of people get into print on demand just selling on a marketplace, not necessarily with a brand in mind. They just create random t-shirts. So in that case, it's not really, that's not really something that you can do because people don't come to you necessarily. They come to Redbubble or they come to Amazon.
But I think even with Redbubble and those, there's still the user that is trusted. There's still from what I understand, at least some kind of ranking mechanism and trust mechanism for that seller and for that designer. That there's at least a star program or something like that that'll say, well, this seller has 4 out of 5 stars. Yeah, that name itself can also be a brand, and I think that can carry through a lot of different things, so that when you are looking at, do I trust the person who made this design, that is something that can be helpful. And it's not always possible. I think you're exactly right, Philip, that it sometimes is you're a part of a bigger pool of designs and people are just buying the designs that they like. They're not really looking for the designer or the artist, or they're just looking for a design. Yeah, that does happen, and it's much harder to kind of differentiate that. But when you can, I recommend building a brand.
Okay.
I think that common misconceptions are that, especially in the print on demand, there is rampant use of others' IP. There's issues that apply that for some reason people get takedown notices and someone doing the exact same thing won't. And it is confusing, and it often leads to this question of, well, why can they do it but not me? And the answer is often there's just so much of it that the brand owner does not have the time and resources to go after everyone. So they're going to go after the ones that, for whatever reason, fit the criteria of the day. So are they going after random ones that they just happen to pick up using a service? Are they going after the highest sellers? Are they going? So I would very much caution everyone to say that everyone else is doing it is not a legal defense. Ignorance of the law is not a legal defense. It is something that it is not a problem until it's a problem in a lot of cases. And sometimes you might go, sell a significant amount and never get any issue, even if it could have potentially been one. Sometimes you might sell a single shirt and then get caught up in one of these kind of sweeps of different brand owners' marketplaces. And it's just important to know that that is frustrating, and I agree, but it is something that just because others are not getting enforcement doesn't mean that no one will enforce it against you.
It's kind of like saying, oh, well, everyone else is speeding, so I should be allowed to speed in my car. Well, if you get a ticket, if you get caught,
right. Yeah,
no one's going to listen to that defense.
You get caught. Yeah, exactly. I think that's the key here is that, if it's fine until you get caught, and then there could be consequences. And I think there's also sometimes that you get caught up in something that is not done in either not in good faith. Some of these takedown notices are filed without, but most of the time it's through ignorance that they say, well, I'm just going to file a mass takedown notice, and a lot of the times they won't get the consequences that I think sometimes are needed. And then brand owners end up kind of feeding into this bad cycle of filing bad takedown notices, and kind of because no one really knows what the standard should be. So You I think I'll pause there because I think the next thing we're going to talk about is takedown notices, or I can just kind of keep going because I think a lot of the folks in the print on demand, this is the scariest thing to get
Mm,
because
mm,
you get enough of these, your account's shut down, and then you have to figure out what to do from there, especially on a platform like Amazon where your account age and reviews and things like that has a lot of value. The takedown notices can be something that are extremely frustrating. So, but I'll pause there and see if there's anything that we should go over kind of before we kind of keep going on takedown notices.
I did have a couple of follow up questions regarding with copyright and trademarks. Am I right in assuming that trademarks you have to apply for, you have to register, whereas copyright is usually automatically applied to artistic works?
Yeah, so there, the trademarks also exist the minute you begin using them if they are distinctive. So in that spectrum, if they get into that space where they are no longer just descriptive words and phrases, then you do technically own a common law trademark in the areas where you can show that consumers recognize you. So common law is geography based, which is very difficult to enforce and to prove, but you do at least have some protection the minute you begin using a trademark and it becomes known in people's minds as connected to your business. There are common law trademarks. You have to register it to expand it out to all four corners of the United States. That it is the gold standard is trademark registration. Copyrights are different. The minute you create something, or your that is copyrightable, you own the copyright in that. You have to be careful if you're working with designers because then it does depend on who owns the copyright based on what's in the agreement. But
Mm,
the person who makes it, the minute pen hits paper, then they finished a creative design, they own it. If you register a copyright, you get access to additional ways to go after infringers, and you can't sue anyone until you've registered a copyright, but it's not necessary. Copyrights are also largely recognized to one degree or another. Even if you create something in the US, it'll be recognized by almost every country in the world. It's called the Berne Convention. And different countries have very different views on what they'll actually enforce, but technically copyrights are reciprocal throughout the world in 99% of countries. Trademarks are country by country. So one person can own a trademark in the US, one person can own it in Canada, the other person can own it in Mexico, all for the same exact mark. And unless the brand owner has kind of registered in those other countries and expands into those other countries, then it could be a problem for future expansion. But copyrights are more global.
hmm hmm And another thing that you said that was interesting to me about the simple words, or let's say it's a T-shirt with just a sentence written out in a font. There's no real design skills or design elements applied to this. It's literally just words typed out. Is that something that's copyrightable, or because it's just a font, it doesn't really apply there?
So a short phrase, there is the copyright guidance says short words and phrases or words and short phrases are not creative enough to be copyrightable. I think there's some gray area there, and I think that if it is a full song lyric that is like a full stanza, I think that you do kind of get into that realm of like, well, yeah, that how much of it are you taking, and does it kind of go towards the heart of what the creative work was? If it sounds really gray, that's because it is. And
Mm-hmm.
I think that definitively we can say single words can never be copyrighted. I trying to think of how that would be controversial, but I think that that is purely the realm of trademark law. If a word is protected on the front of a T-shirt, it is because it is a brand name that is recognized as representing another brand. But phrases, the longer they are and the more they take directly from the source, I think that's when you can start to argue, well, it has become something that is copyrightable. So it will ring the bell or will light up the sign. It depends
Yeah.
on how long it is, but I think that is kind of there's no set standard for how much you can borrow something I wrote about years ago and comes up at least, every 6 months is this idea of a 30% rule. Can I change 30% of something and then it not be copyright infringement? Nothing like that exists. There is no 30% rule. It is, when you're copying something, did you copy copyrightable elements of it, and would it be recognizable as the underlying copyrighted work? And there's a number of different factors that go in, but you don't assume just because you change 30% of it that it would be. Sorry, that's just a misconception I see a lot, and so
Okay.
probably not what you were asking, but good to kind of at least address that up front.
No, it's still interesting to hear your thoughts because I think like a simple T-shirt, for example, that says "I like plants" written out with simple white text, nothing changed. Like, obviously, I'm not encouraging people to copy that as is, but technically, if you copy that exact font with that phrase, you're not really infringing on that person's copyright. I think that's kind of the point I was trying to get
Yeah,
to.
no, I think that's right. I think that the copyright laws are supposed to encourage people to be creative. I think that they have been construed in a way that does not necessarily meet those goals, but copyright protections in the Constitution. That is kind of this protection of works goes back way further than yeah, Mickey Mouse or anything like that. And I think it's important but that's the idea is also that we don't protect the basics. We want people to incorporate those basics into new things and create new wonderful things without monopolizing something like, I like trees or something like
Mm.
that. That's what we don't want to do.
I think it's also important to know for people who get these kind of like takedown notices, if you do get a complaint that your design was copied, but all you did is write out a few words with a font, then you've got something to argue there. But yeah, why don't we carry on talking
Right.
about this
And there's
slide
a
then?
way to argue it. And that's exactly kind of the issue is that so the copyright law has something called the DMCA, the Digital Millennium Copyright Act. It is Congress's answer to the internet. And essentially it says that if I, as a large marketplace, Amazon, eBay, Etsy, all these kind of large, there's no way I can police all of my users' content because if I'm doing that, there's no way I'm ever going to be able to actually run a business. I just provide the marketplace, they provide the content. But if I am specifically told in a certain way that infringing content that infringes on an existing copyright, I have to take action. And if I do, I can't be sued for copyright infringement. It's called the safe harbor. And that is why you will see every website, every reputable website will have something called the DMCA agent. They will have a takedown notice procedure, and it is available everywhere to do in a very similar format. And so it has very specific guidelines. You have to file a takedown notice, and you have to give the ability for copyright law for there to be a counter notice. A counter notice, and this is something to be very careful with because I have had people file counter notices against me. I completely believe them that they didn't know that the designer they were working with infringed on our client's copyright. In my opinion, I don't care that you didn't know. You are responsible for your designer, and you used it. The designer didn't use it, and so they filed a counter notice against us, and they were in the Netherlands. And when you sign a counter notice, you are agreeing to jurisdiction in the United States where that platform exists, that and you're agreeing to accept a lawsuit in the United States. And that is something people don't tend to realize. They're like, oh, I'll just file a counter notice. If you're not correct in your facts when you are filing a counter notice, you have opened yourself up to not being able to argue, well, I haven't ever stepped foot in the state of whatever. Why would I be able to be sued there? Or if you're international, you could be required to accept service because you signed something that said, yeah, I accept service. I am filing this counter notice. So be very careful before just firing off a counter notice. Look into the claims. There are a lot of fraudulent claims made under the DMCA. A lot of people who are pretending to be someone else. We've had people pretend to be our firm and file them. They use a copyright filing that was filed by someone else, has nothing to do with what they actually are providing. They're just trying to mess with their competitors. That happens, and the counter notice is great for those instances. A mean letter is even better because I, write very mean letters to people who do things like that. But it's just, if you respond without knowing what claims are actually being made, you could potentially open yourself up for even bigger issues. We had a client that we were, I still believe we are right. I think that the court will say we are right, but they were in Australia. They got a DMCA request on Shopify. They filed without asking us first a counter notice and then got sued in Delaware, and we're now litigating in Delaware. But yeah, that's fine because they had us as their attorneys, but it was also one that they're like, well, I don't do a lot of work in Delaware. Like, why am I here? And the answer is because you signed it and said I accept service. So just
Good
something
to
to be
know.
careful of. The same is not true of trademarks. A lot of the platforms use the same process for trademarks and copyrights, but there is no DMCA for trademark law. There's no safe harbor. So platforms are not required to treat trademarks and copyrights the same way, and that's why you'll tend to see a lot of kind of weirdness when it comes to people making trademark claims, especially on Etsy and on some of these things that they're like, well, that's my trademark, and I was able to get it registered with the Patent and Trademark Office. And then there's not really a counter notice procedure. They just say, hey, this content's down. And that's because of the differences in laws. And so a trademark claim you might treat very differently than a copyright claim. Both, if they're fraudulent, I write very. Let me be very clear. I am a proponent and fan of nice cease and desist letters. I think you get a lot more done when you're not trying to just scare the crap out of the other side. But if I am on the defense and I am mad about something that a fraudulent thing that was filed, I write very mean letters, and because that reflects, I think, what's needed. And these kind of things, when I get a false thing that says, "Well, yeah, your generic thing." Violated my trademark and our clients are freaking out because they're like, well, is it? I'm like, well, no, we're gonna take care of this. And so those are when I kind of let out my catharsis of wanting to write mean letters. So you might treat those slightly differently. Yeah, the next one is this idea that we see a lot where folks will know or they should know that what they're doing is not trademark protection, it's anti-competitive. And a lot of that happens when folks try to, they come up with a phrase that is used by thousands of different print-on-demand folks, and they see it everywhere. And they say, okay, well, I want to try to monopolize this because it's selling really well, and they will register it they'll file it with the Patent and Trademark Office, but they'll likely talk to a lawyer or they'll read something online that says, well, to register for a shirt or for an apparel brand, it needs to be a brand. So use it on a tag or a hang tag. And so often they'll mock up a tag or a hang tag. It's never going to be how they actually use it, but it's for the PTO. They do it, they sign it, they sign a sworn statement that this is their product only, that no one else has the right to use this phrase. They get it through the Patent and Trademark Office. The examiner looks at this for 45 minutes. They don't really spend a ton of time on it. And then sometimes they're able to get a registration on a common phrase that their sole purpose is to stop others from selling it on one of these platforms. They don't have a brand. Consumers look at it. They don't see it as belonging to one company, and then they use that as an aggressive tactic to try to take down other people. That has happened to my clients, and I have responded with at one point I sent a draft petition to cancel that said, you've got 48 hours to withdraw this or we are canceling your trademark registration. Like, what are you going to do? And we worked it out. But I think that that's the kind of thing that happens more often than I'd like to admit. And
Mhm.
even earlier in my career, we had clients that didn't tell us that this is what they were trying to do, and we had to dig them out of some holes and tell them, "You can't do this. You're out of your mind. What do you like? If you would have told us this, we would have told you this is a terrible idea." And since then, I it really don't go into that stuff at all, and I counsel clients away from that and have them focus on their own brands. But just know it's out there, and that just because someone owns a trademark registration doesn't mean they own a valid trademark registration. And the issue is costs, because you're going to have to spend time and money either threatening to go after them or actually going after that validity and removing their ability to claim this kind of government benefit of a trademark registration. And so
That's crazy.
yeah,
I want to give an example for this because there's
oh
one
man.
one massive big seller, or one of the top sellers in Amazon merch has been for years, a shirt that says, "I'm not old, I'm classic," and it's got like a vintage car on it. And I'm pretty sure someone trademark that phrase. Um, so that would be an example of something that shouldn't be allowed, but it did slip through the net.
Exactly. Yeah, and I
Yeah.
think that a lot of the times, I posted a post on LinkedIn. I can actually share that so far this year, the Patent and Trademark Office has denied about 110 phrases for being widely used phrases that don't function as trademarks. They fail to function as a trademark. Some of them were like I heart PR, I heart hot dads, or something like that. They said these are so commonly used, people wouldn't think of this as a brand. They would just think of this as a phrase on the front of a T-shirt. So the examining attorneys have gotten better, but they are fallible. They have a quota that they're trying to hit, and they often miss some phrases that are commonly used. And then some of them I look at, I was like, I have no idea. There's one that was like yeetus deletus. I was like, I must be too old to understand whatever is going on here. But I think it had some, phrase. I don't know what it was, but they said, yeah, it fails to function because that's a widely used phrase. And I was like, it is? Not one of my clients, but one that I saw. So there's a lot of kind of that going on. And sometimes it is completely innocent, or it might even be, and this is what you need to be careful of, is that not everything that is a widely or a phrase that appears on the front of a t-shirt, sometimes people are able to develop very successful brands that would cause confusion. That yeah, there's phrases that sometimes can become brands, and in the cosmetic space and things like that, that yeah, you have to be a little bit careful because there are some that you're able to kind of develop brand rights, and when consumers see it, they're actually thinking about that brand and not just the phrase in general. So um, be careful about labeling everything trademark abuse. I think that that's what I want to. There's some cases I think that certainly are. Some of them are a little bit more gray as to whether a brand's being built or whether it's actually just trying to be anti-competitive.
And one thing I want to add here as a side note as well, that doesn't mean if there is a trademark phrase that you can now use it in your listings and your designs, because that trademark is kind of unfair, because in the end the marketplace is going to decide whether you're allowed to sell it or not. And if they take down your listing, that's when you have to kind of argue your point, and you're speaking to the Amazon support team, which generally doesn't
Right.
listen very much. So yes, there is a lot of unfair trademarks out there. And by the sounds of it, the reason why they persist is because it takes money and effort to get them taken down, right?
Yep.
But that
Oh, exactly.
doesn't mean that you can safely use them on marketplaces, even if they're not fairly registered.
Yeah, and I like to say that my role is, yeah, I am a trademark and copyright attorney, but mostly what I do is risk management. And every time you use any phrase, you're going to have some risk attached to it. And I think that there's ways to reduce that risk. But if we are in a position where I'm sending that angry letter, you've already spent a pretty good amount on legal fees. And more importantly, your business, and if you're spending money on legal fees, it's because your business is losing money. And whether it's through a takedown notice that gets an account locked down or something like that, that's when, if you can avoid that, then that is preferable. Yeah, but sometimes from a marketing, the risk is worth it and the money is worth it. And that's when you just can be as careful as possible, but then also know what you can do if you do run into issues. So that is takedown notices. I'll briefly go over copyright. Oh, we talked about short phrases. The last thing I really want to talk about is right now the current state of AI generated artwork. A lot of users will use designs that are come out of Midjourney, come out of DALL-E or any of the other um, art generative AI models that are currently out there. The current stance of the Copyright Office is that, and in federal courts who have kind of doubled down on what the Copyright Office has said, is that content created by AI, generative AI models, is not subject to copyright law because a human did not make it, that a computer algorithm made it, therefore it is not subject to copyright law. The good news is that that output is very unlikely to infringe on someone else's copyrights. There's other lawsuits that are going on as to whether the training of the artwork underneath it is copyright infringement, but that's against the models themselves. It's unlikely that the production of designs is going to be a copyright infringement, but it also means that you don't own, from a copyright perspective, the things that come out of these generative AI environments. And so that's very just important to know because it does restrict your ability to stop others from literally lifting your exact design and selling it themselves because there's just not the assumption that you normally would have that if you create a design yourself that you're the author of it because you did not create it, a computer did, and therefore the human authorship thing is not available. Even adding small things to a existing AI is not enough to kind of make it copyrightable. Anything you add to it, if that's sufficiently creative, that itself could be its own copyright. Like if you designed half of it and then the other half was AI, perhaps you could claim that the design, the half that you made was. And then also there's this idea of, well, who would ever know? And there's a very kind of interesting aspect of that of like it's not always obvious when something is AI created. So yeah, that might not be as dire as it sounds if that is a majority of your business is these kind of AI designs because would someone take the risk of copying it hoping that it's AI created? So, but that's just something I think is very important because it is ubiquitous now in the print on demand industry that some degree of the artwork is likely created using AI and that just know that this could change at any moment. I think that there's a lot going on in the background of people trying to catch up with the modern usage of generative AI. But that's just something that kind of my last point I wanted to talk about is that.
Yeah, that's definitely important to note. It is true that if you use AI designs on your shirts, technically people can copy them without any repercussions. But at the same time, um, I wouldn't say that that means AI art generators are useless because again, you can use the graphics as part of your design, which then makes it harder to copy. And besides that, if you have a normal design that you've created with Illustrator, for example, Adobe Illustrator, people will still copy it. They shouldn't, but they
Right.
will still copy it. It does happen all the time. So it's not like there's going to be a different reality using AI designs. It's just that with AI, it's technically allowed.
And there's a lot of questions I think of. We've been using photo manipulation tools. We've been using tools like this for years and years. At what point do we differentiate what something is generative AI versus just a tool that's being used to create another type of work? And I think that the cases they're going to be super interesting. I mean, maybe I'm just nerdy and just find them super interesting, but I think that's just something just to be aware of, and not something that I would say don't ever do it because yeah, that is going to be volume sometimes is good enough when it comes to a lot of print on demand, and you want to just kind of ride the wave of whatever's popular, and then have your own version of it, and then move on. And I think that's definitely just a business consideration.
Now, if you have a registered trademark or even a registered copyright, um, how costly is it for a lawyer or having a lawyer that kind of pays attention to the marketplaces and sends notices of getting infringements taken down? Is that even a service that you offer?
Yeah, so there's a couple different tiers to that. The first is that if you own a registered trademark, then there's monitoring of other people trying to register similar trademarks. That's to kind of keep the marketplace clear of people trying to actually use it as a brand. So once your brand is established, the examiners will deny trademark applications that are similar to yours. Sometimes they get through and you have to oppose them. So there is a level of monitoring of the Patent and Trademark Office itself to make sure that your brand's not getting you're restricted by someone else filing something similar. The other part of that is monitoring the marketplace. As you mentioned, that is a much bigger and difficult thing. And typically it's on a case by case basis of when we do it. And I do it manually. Right now, I've got a client who is dealing with counterfeit games. And our team does a weekly sweep where we go after the counterfeiters, and I know that they're counterfeit because their games spell the name of the company wrong on the back, and it is very quick to know which are the counterfeits and which aren't because but that's one that's done manually, that we bill our time while we're doing it, and that's in a certain project. Is we do other kinds of sweeps on like Alibaba and things like that for with some of our larger clients that it can get very expensive, and it's not something I typically recommend unless you're actively dealing with that level of infringement. There is service providers that, And this is what a lot of people end up getting cease and desist letters, or not cease and desist, takedown notices from. There's service providers. There's one called Red Points that essentially what they do is they plug in all of your designs. They give you this giant list of everywhere where they found the same design on a different website that might not be you. And then they give you the option to press one button, and that sends out the takedown notice, which sounds great. It's super expensive. I mean, depending on how many designs you have, but you can do that, and you can very quickly get stuff taken down without even looking at it and actually doing the correct legal analysis. And it's going to come from red points. And I have both worked for clients who use red points. I have yelled at red points with angry letters. And they're just one. They're perfectly fine. They're not doing the analysis, but they are permitting the owner to hit go on 1,000 takedown notices at once, and it is the owner hitting go, and that's always the case. And so that's where it tends to get more expensive. But I think that a lot of the time it is more for smaller companies, it is a manual process of searching and tagging and filing takedown notices in a way that we've done, but it also is kind of usually when there's a problem.
And that was red points with an S at the end, or
Yes,
red
and
point?
I don't know if I am not actively, they are, I am very neutral on them. I
Okay.
think that they can be used for really great things of taking down a bunch of counterfeits at once. They can also be used by unscrupulous folks to file way overly broad takedown notices all at once with very little oversight.
Well, at least it's expensive then, by the sounds of it. So not everyone can just do it
That's the
randomly.
hope.
Speaking of expensive, talk to me about trademark scams.
Yeah. So if and now it used to be if you filed a trademark, you'd get like these bogus invoices. Now they have shifted to sending it to pretty much anyone with a business. And so you'll get an email that says, "I'm Fred Johnson and I'm a senior trademark attorney at trademarkshield.com" or something like that. And then and they'll look very convincing, and they'll say the right thing. They'll say, well, I was helping a prior client and they wanted to register a name that was the same as yours, and I'm required to reach out to you to ask if you want to register it, which no attorney would ever do. Like, it is shocking to me that it is a scheme I have seen now 40 times or so, different companies all using the same language that says, well, I was reaching out to you because my client wants to register your trademark. Do you want to register it? And like, that is bizarre to me. But they basically have a hard sell of, hey, pay me money and I'll register this, or you're going to lose your rights. And they will aggressively follow up. And yeah, every time a client sends one to me, they're like, hey, is this real? I'm like, no, it's not. Like, and then I post all their information. I redact my client's information, but I blow up the thing and I put it on social media just in hopes that someone will Google it and see that it's not a legitimate person. But you'll be aware of that. And I think that a lot of that is avoided by having a contact, like me, like a trademark attorney that you trust, that you can at least send an email to and say, hey, is this real? Because there's a lot of just junk out there but you also don't want to confuse it for something that could be legitimate. So I always, for my clients, and I'm always willing to kind of just take a quick look and say, yeah, that's bogus, or no, we need to take a look at that.
Now let's get into a few specific examples that kind of often pop up in the POD space because there's a lot of grey areas. We know it depends in a lot of scenarios, but one example that I wanted to talk about is we often see that people use intellectual property, whether it's a movie or a famous logo or a famous band, and they kind of create a parody or a satire of it.
Mm.
For example, the Kiss logo, which has the band members on it, you see designs that say Hiss that then have cats on top showing, right? This is a cat design, but it's very similar to the Kiss IP. Is that technically allowed, or should people stay away from that?
Well, yeah, so that's going to be a tough one because there was a recent case, the Jack Daniels case, where someone filed for, oh, now I'm going to forget. It was the basically it was Jack Spaniels. That's what and so Jack Daniels said, hey, this is confusing, and want to take it down. They said, I have a First Amendment right to parody your company. This is supposed to be a joke on you. And there's actually a difference between parody and satire. Parody is going to reference or make some kind of social comment about the brand itself. So, what about Jack Daniels does Jack Spaniels reference? And I think it's just like, I'm not exactly sure, and neither did the Supreme Court think that. And basically, a satire is going to say, well, I'm using someone else's brand to make a point about something else. Typically, parody is going to be more protected than satire under kind of First Amendment things because satire might actually confuse folks because, for example, the Kiss logo. I'm not sure. I had a very similar issue with a '80s rock band that a client was doing a pet shelter, and it was um, a issue that they had where they were using a name that could potentially overlap with an '80s rock band, and ended up not being a problem. But the what the Supreme Court recently told us is that when you use it as a brand, if you're trying to identify it as this is the brand that I'm using that has that name in it, then they said, well, no, that's subject to normal. Would consumers be confused by it? If it is a commentary on someone else's thing, then that might get heightened levels of scrutiny of, are you purposely trying to confuse people into thinking that it's related? And that's a different analysis. So the overall takeaway is that you're going to have risk. Anytime that you incorporate a logo like I think that Hiss is a good example, that it's like a cat and it's got the Kiss logo. I think that the question is always going to be, would consumers think that this was somehow related to the band? I think of the band, I like the band Run the Jewels. They've got a whole thing that's called, I think, Meow the Jewels or something like that, where they replaced all their beats with cats meowing and released a whole album about that. And so it's very kind of, in that case, I would very much think that they created something that said Meow the Jewels. But something like Kiss, Gene Simmons is a constant pain in the butt and entrepreneur with that. So would he argue that that is something that the Kiss brand would make? I think that there is at least some argument there, but I think that's going to be some risk anytime you're referencing someone else's IP. But it's so widely done that that's going to be a lot lower on the priority list of most brand owners than the actual counterfeits that are
Hmm.
happening in the marketplace. So if I'm going
Yeah.
to spend
So
my money, I'm not going to tell the client, go after Hiss. I'm going to say go after the Chinese bulk sellers of fake Kiss merchandise before you go after Hiss.
yeah, and that brings us back to the marketplaces again, because you have to think about the marketplace as well. If you're selling on it, how do they see it? Because
Right.
they might see it as, okay, this is probably infringing on Kiss, so we're not going to allow it. Like Amazon has their automatic filtering system, the review system, and designs like that very likely to be caught. So the general rule of thumb is, at least what I typically say to people, if your design is selling because the people associated with a brand, with a celebrity,
Right.
with a movie, then you're probably doing something wrong, right? um, and even though maybe under the law it might be legal or you might win a court case, you're adding a lot of risk to your
Yeah.
account, and it's not really necessary.
If you're ever at a place where you have to argue that, you're already in a place you don't want to be for when it comes to a business standpoint. If you're arguing fair use, then have already spent a lot of time and money on something that you potentially could have spent on it, building something else.
On the topic of music, there, one thing that I sometimes struggle with is if I want to use a phrase on a T-shirt, I typically run it through Google just to double check: is there any song names, any song lyrics where this phrase appears just by chance? Because I don't want to get into trouble for trying to rip off song lyrics or a random phrase in my design. And occasionally, yeah, you figure out, okay, there's a big song, a big artist who's actually used this phrase in their title or in a famous song. But other times, you might stumble upon like a band or a musician that has, I don't know, 50 followers on Spotify, and they've used that somewhere in their lyrics. In the first case, if it was Taylor Swift, for example, coming up, I would definitely avoid it from the beginning. But if I found someone with a very small presence who used that in their lyrics, I would probably feel safe to use it in a shirt. What's your opinion on this?
Yeah, I think that that kind of goes more into, well, there's the copyright like grayness of how much is it. Let's assume that it's not a copyright infringement because it is you're not something that is directly lifting from a thing purposefully, all those kind of things. So let's look at it from the perspective of trademarks. Would the average consumer that's buying that shirt think it is associated with another brand. And Taylor Swift is a great example where she's got a empire of brands where people associate very specific things, not just with her lyrics, but with her whole thing. And so I think that's a great example of where short phrases can be excellent trademarks, excellent source identifiers, even if it's not registered. Those all associate, oh, that's a Taylor Swift thing. But if it is just everyone else who's not Taylor Swift, and it's just a phrase, I could probably find any phrase in existence in a song lyric somewhere. And I write songs. I know a lot of the stuff that I write like is not anything I would expect if someone put it on a T-shirt. No one would be like, "Oh, that's Eric's stuff. That's an Eric exclusive." And so I think that a lot of the times like you said, I think it was a great way to say if you are purposefully attempting to associate yourself with a popular artist, or if you find after it goes out there that people are saying, oh, this must be in reference to X, Y, and Z, that's when it can start to be more risky. But I tend to agree that um, a happenstance where it happens to also be a song lyric, then that is a lot lower on the risk spectrum.
I think a good example for this is the Eras tour that Taylor Swift is on or has been
Mm,
on or was on, I don't know. But since then, there's been so many shirts selling that kind of have a spin on that name of the Eras tour. Like in my mom era, in my teacher era, nurse era. And it's not directly linked to her song lyrics, like it's not the title of any of her songs
right.
or in the lyrics, but like you said, that is directly coming from the brand of Taylor. That's why people like it. So yeah, it's always a bit of a difficult one because you're not really copying song lyrics, but you're still benefiting from Taylor's name in a sense.
Yeah, and it's funny you mentioned that because one of the things that the Patent and Trademark Office refused is an individual tried to register "I'm in my villain era," and they said that fails to function as a trademark. That is a reference to a Taylor Swift song. It is not your trademark. They didn't go as far as to say like, well, Taylor Swift owns that, but they did say at least that consumers wouldn't think that came from you. And so yeah, that at a certain degree, I think that there is it's risk. Does Taylor Swift care that these are going out there? I think that there's a lot of actual counterfeits out there that are using her name, her face, and trying to say this is official Taylor Swift gear, and it's much more expensive. But it is all about, do you accept the risk or not?
What about trademarks that have kind of turned into everyday language? So one example that I always think of first is Hoover, like that's turned into a normal word for me, just using the hoovering. But that used to be a brand. I even found a website where there's loads of examples, like 50 examples, like onesie.
Yep.
I just thought popsicle. People use these in their everyday language, and they sell them on T-shirts as well, like use them in their listings. We've got, I think, jet ski. Even jet ski
Jet
is a
ski's a good
brand
one.
name, and some of them are still
Jacuzzi
protected.
instead of
Jacuzzi, yeah.
hot tub. So
Pink.
that has one of my favorite names of a trademark. So there's the spectrum of distinctiveness. I think that's a great name. Then there is a word for when a trademark dies is called genericide. And that means that it has become so ubiquitous with the underlying product, it no longer is a trademark. And it's, yeah, genericide's a real thing. Companies actually put out whole marketing campaigns to avoid it.
Wow.
Xerox was very aggressive in the 90s, saying you don't Xerox something, you photocopy it with a Xerox. And Velcro did the strangest thing I've ever seen, where they did a whole musical YouTube video on it's not Velcro, it's hook and ladder fastener. So hook and loop fastener is the generic
Okay.
phrase for Velcro. You have to be careful because all of the ones that you mentioned, except for jet ski, I don't know if it's still a active company. Popsicle will still claim rights in the phrase popsicle. Thermos will still claim rights in the word thermos. Now they're generally around logos that they use. So yeah, the word popsicle, I in my head immediately think of popsicle in a very specific font that is the popsicle brand. And same thing with thermos. It's got that block letter thermos with the big th, and so I think those are the kind of things that you can't reference the brands, And sometimes the companies will be very adamant that no, we do not. It is not generic. You're just using it wrong. Band-Aid will go to the they'll go to the mat for to saying that this is not a everything is not a Band-Aid. It is a a bandage. And so I think that you have to be very careful with that. There's some very kind of acknowledged things. Murphy bed, for example, it used to be a registered trademark. Escalator. There's some that are actually the companies don't exist anymore, and so that is definitely generic. But for the ones that still exist, I think Gerber owns Onesie. I've never heard them enforce it against anyone, but they do still own a registered trademark in Onesie, which is always baffling to me because I have a 10-year-old and I never would have thought when he was a baby that I was buying a Gerber brand or Onesie. And so, so I think you just have to be careful with those.
That's interesting because jet ski, apparently, according to the website that I'm looking at, is still owned by Kawasaki, the brand who came up with that type of watercraft, I suppose.
Yeah,
And
I guess it is
I
still
just
registered too. Well, I typed it in. The first thing that came up is a design that says jet ski. So I think that also might be something that they might be. Yeah, I guess what would you call a jet ski? That's a good question. Like, what's the generic? That's all what I always think of. Can I think of the generic name for it?
apparently it's
I
a personal watercraft.
okay, sure. Yeah.
This is an interesting example of thing because it is trademark, or I have found a trademark
Yeah.
in class 25 for jet
Hmm.
ski on the use of t-shirts, but it is a typeset trademark. So would that mean if you use it in a specific font and you're trying to literally like copy Kawasaki in a way, that's not allowed? Can you still use it for people who like jet skis on a shirt?
I mean, I would say that based on what you found, there is risk involved
Yeah.
because they at least have the presumption that they own it. Could someone come along and cancel it on the grounds that it's generic? Yes. But if we're having that conversation, I think you're deep into it if you feel like it's going up against Kawasaki to cancel a trademark. And so I think I would be careful about that kind of usage of it. But I think it's also going to be very low on everyone's priority list when it comes to, yeah, I've got a legal budget. How do I spend it? And I would smack my client upside the head if they said, I want to go after that. Someone saying, I like jet skis. I would say, well, what are you doing? Like, you should be going after counterfeiters who are selling fake jet ski brand things on in the marketplace. So
Mhm.
that's just my 2 cents.
What about the fact that celebrity names are usually off the charts,
Yeah.
but politicians, like at the moment, Trump, Kamala Harris, their shirts are flying off the charts, and it seems to be okay.
Yeah, so I think that you get into this question of is it a brand? I think, and there's also a whole different thing. You may have heard the phrase NIL, name, image, and likeness. It is the buzzword because it goes beyond trademarks and copyrights. It goes into this idea that in certain states you've got a right of publicity, that you get to control your commercial image, no one else does. The exception to that tends to be when you're talking about free speech. If you are making political shirts that are not confusing to people as to what the source is, this is saying, Kamala Harris, whatever is my favorite, that
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 lady.
tends to have a little bit more. Well, it looks terrible if takedown notices are filed as a political campaign, but there's also some First Amendment arguments that there is a right to political expression, and this is my political expression that's undercut by the idea that you're selling it. So I could make very good arguments that in certain cases, if you're using the campaign logos, if you're using the campaign, especially photos, you have to be very careful with because the campaigns usually don't even own the photos of themselves. The picture of Trump getting, with his hand up that's owned by a New York Times journalist, I believe, or photographer that has to send out something that says, "Hey, by the way, that's mine. I was in that spot. I took that. You can't just use it." And people are going to do it until until it's a problem. And I think most campaigns won't do takedown notices because they want it is beneficial to them in most cases to have a robust marketplace of people promoting them for them. But I don't think that means that they couldn't if there was a situation where someone was saying official Kamala Harris merchandise. I think they would absolutely be they should and could stop that from happening to prevent people from thinking it's coming directly from the campaign.
So basically, if you're copying, for example, Trump's logo of
Right.
his campaign, then again, you're getting yourself into more trouble than just using a funny one-liner from one of his speeches.
Yeah, I would agree with that.
What about slightly changing trademarks? So one that I've found, for example, in the print-on-demand space, um, is birds aren't real. What if someone saw that and thought, oh, well, maybe I can change the phrase a little bit, and then I'm allowed to kind of use it? For example, birds are just not real, or birds are fake. Does that would the brand owner for birds aren't real still be allowed in a sense to go against that?
If so, that it comes down to a question of likelihood of confusion. That if there's a brand, and we're assuming that that's a kind of protected trademark, birds aren't real. They're using it as an actual
Yeah.
brand of apparel. It's not just one of these kind of fraudulent ones. But if that's the case, then typically there's actually 11 factors, and it depends on which circuit you're in, but that go into determining whether something's likely to confuse. The first one is how similar is the trademark in commercial impression, which is wonderfully vague. The other one is how close are the goods and services. In this case, if it's both for apparel, they're exact. How strong is the trademark? And then my favorite one is number 11, which is anything else. Anything else that could go into whether there's infringement or not, which is silly. But the idea is that the guidance that I would tell people is small changes that don't change the commercial impression could still be trademark infringement. But that could still cause an issue. Would the platform take it down if it's that way? That's kind of a platform by platform thing. They'd have to the further away from it, the low level customer service person who's processing this might say, well, it's not exact, so I'm not going to enforce it. So you tend to get picked up on the net, the kind of dragnet a lot less if you change it, but it doesn't mean that it's not trademark infringement because you added an extra word in between, unless it completely changes the commercial impression.
Just a random question that came to my mind. How come some of the marketplaces, some of the big marketplaces get away with like rampant trademark infringement? For example, Etsy is flooded with the people ripping off Disney blatantly, not just trying to
Right.
make it similar, blatantly ripping off Disney, Marvel, Taylor Swift. Do you know why that's the case? Or
Yeah, well, in some cases, it is just the pure volume of folks that are doing it and the focus of the brand. Because under the US trademark kind of regime right now, and the same thing with the copyrights, the way it's set up is to encourage brand owners to protect their own rights, not have the platforms monitor the marketplace. There's an increase in willingness to do that so that Congress doesn't pass a law that makes them more likely to be, and there is something that's called the Shop Safe Act that does require a bunch of factors that Amazon and Etsy would have to do, like making seller information public, making sure that we know what country of origin they come from. And this is all the screening that Amazon does is all to avoid congressional oversight and saying, hey, you have to do this. They're like, no, look, we'll police it ourselves. We're good. I think Etsy's got less of a filter with that, but it also is, compared to Amazon, much smaller. And so a lot of brand owners spend their time going after the Amazon side of things because that tends to be a lot more damaging to their bottom line than Etsy, which is more of a you know one-off creative place where people are kind of buying one-off designs. It's not usually in bulk.
Mhm. Thanks a lot for your time. It was great to finally talk to an expert about this. Hopefully, we were able to lift some of the confusion. And again, we'll leave Eric's link. I'll leave Eric's links in the description down below if you have further questions or if you want to work with him. And yeah, thanks a lot for your time, Eric.
Yeah, thank you so much. I really appreciated talking to you.